just remind you to turn your phones to silent. All that sort of stuff. Can I just first of all thank Raymond for chairing the committee last week. I was in London. Move on to apologies. I don't think we've received any. Sure haven't. Okay. We're going to change the agenda around a little bit today because of the votes in the chamber. So get through as much as we can, and then we'll start the first evidence session once the first set of votes are over, just to make sure we're not interrupted during that. We'll play it a little bit by ear depending on when the bells go off, which will be probably the next 5 or 10 minutes, I would anticipate. But if we move on to agenda item 2, is a draft minutes of the meeting held on the 4th of February. If you just glance over those pages 5 to 11 of your meeting folder, and if you're content that they're an accurate reflection of the meeting, please let me know. Everyone happy enough? Yeah. Yeah. Thank you. Agenda item 3 then, matters arising. Item 1 is the Assembly research paper on the Attorney General's proposed amendment to the Justice Bill. At the meeting on the 21st of February, the committee agreed to request a research paper on the position in England and Wales, Scotland and the Irish Republic in relation to the power of the Attorney General for Northern Ireland under the Coroners Act 1959 to direct an inquest on whether statutory power to obtain papers is provided. The research paper is at pages 13 to 21 of the meeting folder and will also be included in the bill folder. So it's just to note at this stage, but it will be useful when we are considering the proposed amendment when we return to this in the coming weeks. Agenda item 2 is a response from the Departmental Solicitor's Office regarding the Attorney General's proposal for legislative provision for rights of audience for lawyers employed in his office. A response has been received from the DSO to the committee's request for further information regarding the Attorney General's proposal. The committee noted the view of the Department Solicitor's Office that while not supportive of the proposal, if such an exemption were to be granted to staff in the Attorney General's Office, then it should not be restricted to those staff, but should also be available at the least to staff in DSO, and requested further information on the level of staff in DSO who should receive rights of audience. The DSO has indicated that it would initially want all 12 staff on the Judicial Review team to have rights of audience, and in due course it would want to give further consideration to widening the rights to the remaining 12 lawyers in the litigation division. So again, members, if we can just note the response, and again this will be useful when we return to the matter in the coming weeks. If we can move on then to item 3, is a letter from the PPS regarding the Attorney General's proposal. A letter has been received from the Director of Public Prosecutions regarding the Attorney General's evidence at last week's meeting on his proposal for legislative provision for rights of audience for lawyers working in his office, and whether the rights should extend to staff in the PPS. A copy of the letter can be found at pages 3 and 4 of your tabled papers. The Director has clarified a number of issues and has offered to come to the committee to discuss the matter further if it will be helpful. So, members, just note the correspondence. Again, this will be useful as we return to the matter in the coming weeks, unless anyone wishes to hear from the Director. No? Okay. If we move on then to item 4, a response has been received from the Department concerning the provision of funding to the voluntary search and rescue organisations for 2015-16. Apologies this before when we discussed it with the Minister. A copy is at pages 5 to 7 of your tabled pack. The Department has indicated that discussions are still ongoing in relation to the transfer of funding from the Department of Culture, Arts and Leisure in relation to 3 organisations that previously received grant assistance from that department. The Department has also outlined that one of the recommendations of the review of the Strategic Framework Arrangement for Search and Rescue in Northern Ireland was that funding should be made available to all search and rescue organisations, of which there are 9 in total. The Department has invited bids from all 9 groups for funding for 15-16, and once received, the Minister will consider both the merit and available resources. The Department has highlighted that it does not have significant resources to allocate to this service, and having explored the possibility of using assets recovery or proceeds of crime funds, has concluded that the service does not fall under the criteria for such funding. Members, it's just a note unless any further information is requested from anybody, or happy enough at this stage.
Just if I could ask, because this actually came up in the Ballymena ECSP last week, whereby they opened up a tranche of asset recovery money, and I know that different ECSPs in different areas may open up tranches at different times. I don't think it's coordinated centrally, but even if it is, whilst the Minister's telling us that they don't fall under the criteria being funded by his department that way, I'm wondering can they still qualify to apply through the PCSP? I'm not 100% sure if that clarifies that for us, because I've basically just sent that application form out to all the community groups and all the sports clubs that I help in my area, so I passed it on to them just to see if there was any chance. But that, if we could just have that wee tweak
That's fine.
clarified.
I'll get that clarified. That's no problem. That's okay. Okay then, folks. Item 5 is the forward work programme. An updated forward work programme for February and March is now at pages 8 to 16 of the tabled pack. The meeting at Niacaro's offices has been rescheduled for Wednesday the 25th of February. The Lord Chief Justice will attend the committee on the 18th of March to discuss the rationalisation of the courts estate and proposed court closures, and it's hoped that that meeting will take place in the Royal Courts of Justice. Departmental officials will also attend that day to brief the committee on the proposals. Members, can I also suggest, just in advance of the division bells, that we maybe move on to agenda item 8, and then we will bring the start our evidence session after the division bell. So, agenda item 8 is the police pension regulations issue that's been on the agenda the last number of weeks. Refer members to pages 106 to 217 of your meeting folder. The committee considered further information related to this proposed statute rule, which will provide for the introduction of a new career average revalued earnings pension scheme for the PSNI and PSNI reserve at the meeting last week. The correspondence indicated the Department does not agree in principle that police pensions should provide for possible pensionable age of 55 without penalties, similar to that provided for firefighters, and outlined its view that there is no realistic prospect of amending primary legislation in time to avoid monetary penalties and ensure that police officers have access to a live pension scheme. Members again expressed concerns about the proposals, and the committee agreed to request further information from the Department on the exact changes that are needed to the primary legislation to provide for a police pension age of 55 without penalty. Members also agreed to seek the views of their respective parties on the possibility of changing the police pension age and discuss the matter again here today. The Minister replied yesterday. The letter is at pages 18 to 20 of the tabled packs. The Minister has provided information on possible vehicles for making legislative change, but emphasises that there is no realistic prospect of amending primary legislation before the new pension scheme is due to be in place on the 1st of April 2015. He has indicated that any proposed change to the normal retirement age would require detailed analysis to understand the financial implications and how these might be met, and there would be a need to have a targeted consultation of at least 6 weeks. He's again also stated that failure to have the new regulations and scheme governance arrangements in place would incur an estimated penalty of £60 million per year to the block grant. PSNI officers would not have access to a live pension scheme with effect from April of this year, and if a change is introduced in Northern Ireland, there will be a loss of parity with other UK forces. Members, I am aware that last week it was agreed that people would go back to their parties, get their party views and report back on this. I'd be keen not to have too much of a debate and rehearsal of the arguments we've heard before, but it might be useful if people can feed back in terms of their party positions on this, and we can decide whether or not we indicate to the Department that we're content, or whether we simply wish to note it, allow the Minister to table it, and we'll have a vote when the SL the statutory rule is tabled. So,
Chair, could I just intervene, because I raised the point initially. We may be looking at the wrong thing here, and I say that guardedly, because I'm not sure. The point I was making in relation to all this is pension age is fixed at 60.
yep.
Right? But in relation to the police, there is a variation, 55, right? But there is a penalty imposed for every year well, it's not a penalty, an actuarial deduction is made for every year between 55 and 60. So in other words, you would lose, if you retired at 55, you'd lose 25% of whatever your pension is calculated to be, because you're retiring that much earlier. But you're permitted to retire early. That's been a concession. So it's not, in a sense, we're not talking here about the retirement age, we're talking about the consequences that flow from you taking up the early retirement at 55, right? So the point I'm making to you, Chair, is that this narrows the issue. I haven't looked at the regulations in detail, but and they're difficult to understand. I've looked at the commentary of the police representation body, which is interesting and quite informative. But I can't see within those regulations where there is mention of this early retirement at 55 being permitted. But I know it was negotiated. It's referred to by the Police Federation. It's referred to by Ms Crawford and I think Sonia Hoskins in their evidence to the committee. The point I'm making to you, Chair, in a fairly roundabout way, I'm sorry, but I think it has to be made properly, is this. It is the actuarial deductions that we should be looking at. Is there any way in which those actuarial deductions could be modified within the context of the regulations? And there is also built into this whole process a review, as I understand it, in relation to police pensions. Now, that might just be a notional thing because this governments always give reviews and never do anything about them, but it's been built in. What I'm wondering is, on this issue of deductions, can we get some further information as to how those deductions can be addressed? Because it seems to me the Minister has ruled out a legislative vehicle, a practical legislative vehicle before the beginning of April. Therefore, it doesn't seem to me likely that we can do it that way. But I think if there was the will around this table, I think we could introduce legislation ourselves, or at least the executive could introduce legislation itself, effectively urgent or emergency legislation, to get it through, if that was required to deal with this particular issue. But it does seem to me that the idea of simply changing the age in the primary legislation is unnecessary, having looked at this. And I could be wrong on this, Chair. I'm subject to correction on this, but I think it's worthwhile looking at that. And if you had a situation where you could change the actuarial deductions to, say, 1% instead of 5% per annum, it might meet the justice of the case that the police are putting forward. It certainly would reduce the huge impact of a 25% deduction in pension. And I think the police are realistic enough to realise that you cannot change the whole scheme, and I don't think anybody around this table is expecting that be done. The other point which the Minister makes forcefully, and which carries more weight for me, is the fact that the scheme has to come into effect, has to go live on the 1st of April 15. So that's a technical problem, but a serious enough technical problem.
Okay, thank you. Any other?
I'm trying to be helpful, Chair. I'm trying to find a way of addressing what I think is a legitimate concern on the part of the PSNI officers.
Anyone else? Tom?
Chair, just to ask a question, how many officers, a rough idea of how many officers this is going to affect?
I think I don't know that the figure. I mean, there will be a huge number of officers affected. The issue is whether or not the difficulty with this is that their representative body have agreed to a national agreement on this. And there is a group of officers who clearly are unhappy with how they have been represented by the Federation. Now, whilst that may be a legitimate concern, if their representative body have agreed to this, I think that is a significant issue. And I know that we've talked about before about the potential financial penalties, of the possibility of whether or not it will be possible to introduce changes to this, and the Minister seems adamant that there's not the possibility of it. But I just think we're at a point now where we give an indication to the Department on whether or not we're content. If we're not content, then it's up to the Minister whether he wishes to table this, which he will table it, and then we will just have a vote on it when it comes back to the committee again. But my understanding from last week is that the parties were to report back on their view on it, whether or not they're content. So I'm just looking around the room to hear from some of the other parties and whether or not they were able to do that.
But what are the parties content with or not content with? I mean, that's the question, really. If my point is, if there is an easement in relation to the effectively penalties that are imposed on officers returning early, if there's an easement in relation to that, is that possible through these regulations? And that does not mean having to change the primary legislation. That's the point I'm making. Now, I may be totally wrong about this, but I think it's worthy of exploration before parties actually make their minds up in relation to it.
Tom?
Chairman, I'm just looking at the bill itself, and again,
Yep.
give way to maybe Alderman McGuinness on this, but it does say that normal pension age for such pensions on the scheme, anyway, it goes on. And such regulations may specify any age not exceeding 60 but not less than 55. Now, I don't know whether that's only for the firefighters aspect, which it may be, because it does mention firefighters in the previous paragraph. The other issue is, I know that Minister had written this in the table packs. He did mention a bespoke amendment bill to be taken forward specifically for the purpose. But again, he's talking about 9 months to 1 year from executive approval. If there was broad agreement from parties, could that not be done through accelerated passage?
Yeah.
If there was a general agreement, because I know, talking from a party point of view, Chair, I'll just give you this when I am speaking, they're not content that all avenues have been explored properly at this stage.
I mean, our understanding, I mean, notwithstanding what Alban said today, because I think it is worth exploring, but I mean, our view of this was that it does require primary legislation. That will take us beyond the date, even with accelerated passage, and then the practice kick in. And that's the concern. And then you have the backdrop to that is that, you know, and the chair's already said it, whether or not these people were properly represented at the negotiation. You know, there was an obvious gap in the fact that the firefighters were able to get this and they didn't, so that you can understand the grievance. But the big decision for us will come the 1st of April. You're going to be penalised, and there will not be primary legislation. Although what you're saying about how it can be done is maybe worth asking.
And the other issue I've raised, Chair, is the review, which is mentioned. I can't specifically identify where it's mentioned, but there is mention in the papers forwarded by the Police Federation of a review, and I think Ms Hoskins or one of the other officials referred to it as well.
Okay, members, we've got our first set of votes here, so we'll suspend and return as soon as the votes are completed, and we'll pick up where we left off.
21.